The timestamp on the court filing showed 3:47 a.m., but I had been home with food poisoning that entire night. My name is Colin Blackstone. At 42, I had built my reputation as public policy partner at our fast-growing practice in Raleigh, handling municipal contract disputes and regulatory compliance matters. The firm had tripled in size over 3 years, and I'd personally brought in 12 major clients. That Tuesday morning, I stared at my computer screen in disbelief. The electronic filing system showed a motion to dismiss filed under my bar number in the Henderson County infrastructure case. The document contained language I'd never written, admitting to procedural errors that could cost our client millions. I pulled up the original draft from my secure files. Clean. Professional. No admissions of fault. But the version filed with the court contained 3 paragraphs I'd never seen before, buried in the middle of standard boilerplate language. Subtle enough to pass casual review, damaging enough to destroy our position. My hands trembled as I checked the access logs. Someone had logged into the case management system using my credentials at 3:47 a.m. The IP address traced back to our office network, but the building's security system showed no entry records for that time. I called our IT administrator, Archibald Hoffman. Checked the server logs for Monday night. Someone accessed my files. "Give me 10 minutes," he said. While waiting, I reviewed other recent filings. The Morrison Municipal Bond case showed similar anomalies. A brief filed 3 weeks ago contained language suggesting our client had violated disclosure requirements. Again, my digital signature, my bar number, but words I'd never written. Archibald called back. "Your login credentials were used from workstation 12. That's the conference room computer. Who has access to that room after hours? Building security, cleaning crew, and anyone with partner-level key cards." I hung up and walked to the conference room. The computer was password protected, but someone with my login information could access everything. My case files, client communications, billing records, everything. Back at my desk, I opened the Henderson County file and began documenting every discrepancy. The altered pleadings weren't random mistakes. They were surgical strikes designed to undermine our legal position while appearing to be my own admissions of error. My phone buzzed. Text message from an unknown number. "Check your email now." The email contained a single attachment, a screenshot of my computer screen from last night, showing the Henderson County motion open for editing. The timestamp read 3:47 a.m., but the reflection in my office window showed someone else's silhouette at my desk. Someone was setting me up. Someone with access to my credentials, my office, and intimate knowledge of my cases. Someone who knew exactly how to make it look like I was sabotaging my own clients. I printed the screenshot and locked it in my desk drawer. Then I began making a list of everyone who'd had access to my files in the past month. The list was shorter than I'd hoped, and every name on it belonged to someone I trusted. My door opened without a knock. Celeste Hoffman, our managing partner, stepped inside with a grim expression. "Colin, we need to talk. The Henderson County client just called. They're threatening to sue us for malpractice." 3 months earlier, everything seemed perfect. Our firm had just landed the biggest municipal contract in Raleigh's history, and I was riding high on a string of successful policy victories. Celeste Hoffman had promoted me to public policy partner after my work on the downtown development initiative saved the city $12 million in federal compliance costs. That's when Archibald Brennan joined our team. He came with stellar credentials from a Charlotte firm and an impressive track record in municipal law. Celeste introduced him as my new co-counsel, someone who could help manage our expanding caseload. "You two will make an excellent team," she said during his first week. "Archibald has the technical expertise to complement your strategic vision." I welcomed the partnership. Our practice was growing faster than I could handle alone, and Archibald seemed genuinely eager to contribute. He stayed late reviewing case files, asked thoughtful questions about our client relationships, and quickly mastered our case management system. "I want to understand your approach completely," he told me during our second week working together. "Your success rate is remarkable. There must be specific strategies you use." I appreciated his thoroughness. We began sharing everything: client notes, legal strategies, even my personal templates for municipal filings. When the Henderson County bond issue arose, I brought him into every planning session. They shared private client notes to help me prep for a pitch, I explained to Celeste when she questioned our collaboration level. It's the only way to ensure consistency across our cases. Archibald absorbed everything quickly. Too quickly, I realize now. He memorized my writing style, my legal arguments, even my preferred citation formats. He studied my digital habits, noting when I typically filed motions and how I structured my workdays. The first warning sign came 6 weeks into our partnership. I found him in my office at 7 a.m., using my computer. "Sorry," he said, logging out quickly. "I couldn't access the Morrison file from my workstation. Network issues." I didn't think much of it. We all shared resources when technology failed, but I noticed he'd been staying later than usual, often working past midnight according to the building's security logs. The second sign was subtler. Clients began mentioning conversations I didn't remember having. The Henderson County treasurer referenced a discussion about disclosure requirements that I'd never initiated. The Morrison Municipal Authority mentioned concerns about compliance issues I'd supposedly raised. "I think there might be some confusion," I told them. "Let me review our communications and clarify our position." But when I checked my email records, the conversations existed. Messages sent from my account, using my professional tone, discussing legal positions I'd never taken. The timestamps showed they'd been sent during evening hours when I was typically at home. I confronted Archibald about the discrepancies during our weekly case review. "Maybe you sent them and forgot," he suggested. "We've all been working long hours. It's easy to lose track of routine communications." His explanation seemed reasonable, but something felt wrong. I began paying closer attention to our shared files and noticed subtle changes in documents I'd previously finalized. A word here, a phrase there, nothing dramatic enough to trigger immediate concern. The breakthrough came when I decided to check our case management system's audit trail. Every login, every file access, every document modification was logged with timestamps and user credentials. What I found made my blood run cold. My credentials had been used to access files during times when I was provably elsewhere. Court appearances, client meetings, even a weekend family wedding in Charlotte. The logs showed Colin Blackstone working on cases while I was 3 hours away. I printed the audit reports and cross-referenced them with my calendar, my credit card receipts, even my cell phone location data. The pattern was undeniable. Someone had been using my login credentials for weeks, systematically accessing my files and making unauthorized changes. But the most damaging discovery came when I examined the actual document modifications. The Henderson County motion wasn't just altered, it was strategically sabotaged. Language had been inserted that implied our client had knowingly violated federal disclosure requirements. Similar changes appeared in the Morrison file, the downtown development contract, and 3 other major cases. Each alteration was designed to create legal liability while maintaining the appearance of my professional work. The changes were subtle enough to pass casual review but devastating enough to trigger malpractice claims and regulatory investigations. I confronted Archibald that evening in the conference room where the unauthorized access had occurred. "I know what you've been doing," I said, placing the audit reports on the table between us. His expression didn't change. No surprise, no denial, just a calculating look that told me everything I needed to know. "How long?" I asked. "Since my 2nd week," he said calmly. "Your password was pathetically easy to guess. Your daughter's name and birth year?" "Really, Colin?" "Why?" "Because Celeste promised me your partnership track, if I could demonstrate superior performance. Sabotaging your cases while building my own portfolio seemed like the most efficient approach." The confession hit like a physical blow. Not just the betrayal, but the calculated nature of it. He'd spent months studying my methods, earning my trust, and systematically destroying my reputation. "How much damage?" I asked. 6 major cases compromised. Approximately $2 million in potential client losses. 3 bars complaints already filed, with more coming once the Henderson County situation fully develops. He stood to leave, then paused at the door. The beautiful part is that it's all documented under your credentials. Even if you prove I had access, you'll never convince anyone you didn't authorize the changes. Your career is over, Colin. Mine is just beginning. The next morning, I walked into the managing partner's office with everything. The audit reports, the access logs, the document comparisons, and a detailed timeline of Archibald's activities. Celeste Hoffman sat behind her mahogany desk, reviewing quarterly numbers. "We have a serious problem," I said, placing them before her. She spent 20 minutes examining the documents. Her expression grew darker with each page. When she finished, she leaned back in her chair and studied me carefully. "This is devastating," she said finally. "Not just for you, but for the entire firm." Archibald confessed last night. He's been systematically sabotaging my cases for months. Do you have that confession recorded? No, but the digital is overwhelming. She picked up her phone and called the firm's general counsel. Within an hour, we had an emergency partners meeting scheduled. By noon, the conference room was filled with the firm's senior leadership. I presented them methodically. The unauthorized access patterns, the document alterations, the timeline correlation between Archibald's activities and my case problems. The room grew quieter with each revelation. The Henderson County motion alone could trigger a malpractice suit exceeding $5 million, I concluded. We need to immediately. Partner discussions followed for 2 hours. The consensus was clear: immediate suspension pending investigation, client notification protocols, and damage control measures. But Celeste raised a critical concern. "We need external validation," she said. "This level of document manipulation could constitute criminal fraud." 3 days later, economic crimes investigator Patricia Wilson from the Division of Lawyer Trust Fund Compliance arrived at our offices. Her investigation was thorough and methodical. She interviewed staff, examined our case management systems, and reviewed every document I'd flagged. "Mr. Blackstone," she said during our final interview, "yours is compelling. We're opening a formal investigation into document fraud and professional misconduct." The investigation moved quickly. Patricia's team discovered additional I'd missed. Archibald had been selling confidential client information to opposing counsel in 3 cases. The document alterations were just one component of a broader scheme. Within 2 weeks, criminal charges were filed: wire fraud, computer tampering, and professional misconduct. The State Bar launched parallel disciplinary proceedings. But the damage to our clients required immediate attention. I spent the next month working 18-hour days, rebuilding compromised cases and managing client relationships. The Henderson County motion was refiled with corrected language. The Morrison contract was renegotiated. 3 other cases required complete strategic overhauls. The firm's response was decisive: full disclosure to affected clients, fee reductions where appropriate, and comprehensive case reviews. We hired an external cybersecurity firm to audit our systems and implement stronger access controls. Archibald's trial began 6 months later. The story was overwhelming. Digital forensics confirmed every unauthorized access. Document analysis proved the systematic nature of his alterations. His confession to me, while not recorded, was corroborated by the physical. He received 3 years in prison and permanent disbarment. The civil settlements with affected clients totaled $1.8 million, covered entirely by our malpractice insurance and firm reserves. But the personal cost was significant. My reputation required months to rebuild. Client trust had to be earned back case by case. The partnership track I'd worked toward for years was delayed indefinitely. The firm implemented new protocols based on the investigation findings. Multi-factor authentication for all case management access. Regular audit procedures for document modifications. Mandatory cybersecurity training for all staff. I also discovered I wasn't Archibald's only target. Two other associates had experienced similar but less severe sabotage. We formed an informal support network, sharing information and helping each other rebuild our practices. The experience taught me that professional betrayal often hides behind personal relationships. Archibald had been more than a colleague. I'd considered him a friend. His systematic destruction of my work while maintaining that friendship was perhaps the most disturbing aspect of the entire situation. Patricia Wilson's investigation revealed the full scope of his activities. Beyond the document alterations and information sales, he'd been manipulating billing records and client communications. The total damage exceeded $4 million across multiple victims. Justice was served, but the scars remained visible in our daily operations and professional relationships. 12 months later, I stood in my new office overlooking downtown Durham. The nameplate read, Colin Blackstone, Senior Policy Counsel, at a respected nonprofit focused on legal ethics reform. The view was different, but the work felt right. The transition hadn't been easy. Leaving private practice meant abandoning the partnership track I'd pursued for 8 years. But some betrayals change your perspective permanently. I needed work that felt meaningful beyond billable hours and client development. My new role involved drafting model ethics rules for state bar associations. The irony wasn't lost on me. Archibald's betrayal had inadvertently prepared me for this work better than any academic study could have. The firm in Raleigh had recovered. New security protocols were working. Client relationships had stabilized. My former colleagues sent occasional updates, but I'd moved beyond that. Archibald served 18 months before early release. His disbarment was permanent. Last I heard, he was working in insurance claims adjustment. Some falls from grace are irreversible. Patricia Wilson and I maintained professional contact. Her investigation had uncovered similar schemes at 3 other firms statewide. The patterns were remarkably consistent. Trusted colleagues exploiting access, manipulating documents, selling confidential information. My current work includes developing early warning systems for law firms, digital audit trails that flag unusual access patterns, mandatory reporting protocols for suspicious colleague behavior. I run campaigns for anonymous legal reporting lines that protect whistleblowers from retaliation. The personal healing took longer than the professional recovery. Trust doesn't rebuild on a timeline. But working with ethical attorneys daily helped restore my faith in the profession. My apartment was smaller now, but peaceful. No late-night case preparation. No weekend client emergencies. No wondering which colleagues might be undermining my work while sharing coffee in the break room. The nonprofit's mission statement hung framed behind my desk, protecting the integrity of legal practice through education, prevention, and accountability. Simple words that carried weight after everything I'd experienced. Some evenings I still thought about those altered pleadings. The systematic nature of Archibald's betrayal. How easily trust could be weaponized against the person offering it. But those thoughts came less frequently now. The work here mattered. Every ethics rule we drafted, every reporting system we implemented, every training program we developed, might prevent another attorney from experiencing what I had endured. My colleagues respected my background without requiring detailed explanations. They understood that sometimes the best advocates for ethical reform are those who've witnessed its absence firsthand. The silence in my new office was different from the tense quiet that had filled those final weeks in Raleigh. This was peaceful silence. Productive silence. The kind that comes after justice has been served and lessons have been learned. It was finally over, and the silence felt earned.